Joseph Colbert, and I am a lawyer with Colbert Law. And the topic for today is board member and board risk and liability regarding opening swimming pools during this COVID-19 pandemic that we're experiencing this summer. Very difficult decision for board members to make. There's a lot of pressure on them by community members to open pools. Um, Children need a place to go, people want a place to go, but um, what we're finding is that the risk and liability to the association and board members is much too high. Boards are deciding not to open because of those risks and liabilities. For one, insurance. Most boards like to say, oh, we have insurance, but the insurance professionals are telling us that the insurance that most boards have in place, it's not going to be responding to COVID-19 type of claims. So if someone's in the pool and gets sick, or even if they're not in the pool and they get sick from COVID, you're likely going to experience a claim. It could be anywhere from now to 3 years. The statute of limitations for negligence claims is 3 years. So it could be another 3 years before you see a claim. And when you put it into your insurance carrier, what the insurance professionals are saying is that there's all sorts of exclusions in these policies covering viruses. There's no specific exclusion for COVID, so they're going to have to wait and see what type of claims are made, and in all likelihood there won't be coverage. So what does that mean to you? That means that if there's no insurance coverage and there's a claim, you're going to have to go hire your own lawyer to defend the claim. And if there's a judgment or a settlement for money, you may end up having to pay that yourself. That means all of your owners are going to be partially responsible for that payment. So with that insurance definitely responding to these type of claims, it's very risky to open up your pool. So associations that decide to open, they talk about releases and waiver type of agreements, which are great. You definitely need that. You're going to need that when you eventually do open your pools. But the problem with those are they're just a defense, meaning you still have to get a lawyer, still have to incur legal fees if someone gets sick and there's a claim that's not insured. You're going to have a lawyer defend you, and they're going to have to use that release and waiver agreement, and that'll be a defense for you. You may lose, you may win, but certainly that's another risk that you have to be aware of when you decide to open up the pool. Even with those type of agreements, you're still going to have a lot of costs and expenses potentially in the future. Individual board members can be sued if they are making purely business decisions in the best interest of your community. There's something called the business judgment rule, which will protect them from liability as an individual. But if they're making self-serving decisions, my kid wants to go in the pool, that aren't in the best interest of your community. If you have older people in your community, you have people with different type of illnesses that make them more susceptible to a COVID-19 type of an infection and consequences of it. If it's not in the best interest of your entire community to have your pool open, individual board members who arguably self-serve themselves with decisions to open up a pool could find themselves in a lawsuit, could find themselves at the end of a blame game. Even if there is no lawsuit, think about somebody in the community catching COVID and then either getting very sick or dying. You can have other community members catch it. That's a problem, as everyone knows. But think about being blamed as a board member for that happening. That's not an instantaneous type of thing. It could go on for years. We don't really know how long this will go on, but certainly you should be concerned about being blamed because you are the face of the organization. If you're going to open, you're going to have to spend some legal fees. You're going to have to get some good legal documents in place, good board minutes in place, really protect you as a board for making this decision, because in all likelihood, someone will find themselves on the other side of a lawsuit having to defend their actions. So that needs to be very carefully done. That means legal fees and costs. If you decide to close, some boards that we represent, I've actually taken it to the owners. Take it off the board's back. Have a special meeting of owners if you can. And in many cases, because of state regulations, you still can't have an owners meeting. So think about this. You want to open up your pool, but you can't have an owners meeting to let owners decide to open a pool. So that is a problem. If you decide not to open, the life, safety, and health reasons for you not to do that are strong. There are defenses to any kind of claim that you breached your obligations by not opening the pool. You breached your obligations by not providing this amenity to, for example, condominium unit owners who have that as part of their common charge expense. The board can make these decisions, and in this particular instance, it appears that for most of our communities, that decision has been that the risk and liability far outweigh the benefits of opening up your pool this season. If you decide not to open, there's plenty of things you can do to prepare for next season. And I hope this helped you. And if you have any questions, feel free to reach out to us. Take care.